Okay, Ohio Laws and Administrative Law Rules, Legislative Service Commission, Chapter 1509, Division of Oil, Gas Resource Management, Oil and Gas, Section 150901, Division of Oil, Gas Resource Management, Oil and Gas Definitions. Alright, as wells mean with a borehole, wheel with a drill, bore with a shape of the production, extraction, injection, any gas, liquid, mineral, including potable water to be used as such, but include the natural artificial brines of oil field waters. Will include stratigraphic well. Oil means crude petroleum oil or all other hydrocarbons, regardless of the gravity produced in liquid form. Ordinary production results do not include hydrocarbons originally gaseous phase in the reservoir. Gas means all natural gas, all other fluid hydrocarbons not in oil, including condensation. Condensate means liquid hydrocarbon separated at or near well pad along gas production gathering system prior to processing. Pool means underground reservoir containing common accumulation oil, gas, or both. Does not include gas storage reservoir. Each zone of geological structure completely separated with the other zone. Same structure may contain a separate pool. Field means a general area underlaid or one or more pools. Drill unit means the minimum acreage or which one or well may be drilled. Does not apply with the well injection gas into. Removing gas from a gas storage reservoir does not apply to stratigraphic well. Waste includes all the following physical waste, a term generally understood in the oil and gas industry: insufficient, excessive, improper use, unnecessary dissipation, reservoir energy, inefficient storing oil, gas, locating, drilling equipment, operating, producing oil, gas, well manner tends to reduce quantity of oil, gas, ultimately recovering under prudent, proper operations from the pool. Drill the cause for the trend to cause unnecessary or excessive surface loss to the destruction of oil, gas, some of the underground structure, surface waste, production, storage, oil, gas, condensate, however caused. Correlative rights means a reasonable opportunity to every person entitled thereto to recover and receive oil, gas, and of the person tracked with the tracks equivalent thereof without having to drill unnecessary wells and incur with the unnecessary expense. Tract means a single individual parcel land, partial single individual parcel land. Okay, owner, unless referring to the mine. To a mine means a person who has the right to drill on track a drilling unit drill in to produce a pool to appropriate oil, gas produced therefrom either from the person or others, except for the person ceased to be an owner with respect to the well when well has been plugged in accordance with the applicable rules adopted to order to issue under this chapter. Owner does not include the person obtaining the lease of mineral rights for oil and gas in the parcel if the land does not attempt to produce oil and gas as well. Obtain a permit under this chapter for a well and entire interest of the well transferred person in accordance with the Division B, Section 1509-31 Revised Code. Royalty interest means a freeholder's share of the production well except for the stratigraphic well. Discovery well means the first well except stratigraphic well capable of producing oil and gas commercial quantities from a pool. Prepared clay means a clay in the plastic thoroughly saturated with freshwater weight with a consistent grit enough to sell through saltwater well, which is to be used except for the otherwise approved with the Chief of the Division of the Oil and Gas Resource Management. Rock sediment combined cutting and residue drilling sedimentary rocks formation, excavation and workings or mine or pillar have the same meaning. Section 156101 of the Revised Code. Coal bearing township means a township designated as such by a Chief Division Mineral Resource Management under 156106 of the Revised Code. Gas storage reservoir means a continuous area of subterranean prairie, sand, or rock stratum or strata in which gas is to be injected for the purpose of storing it therein or removing it therefrom. Includes a gas storage reservoir defined in Section 157101 Revised Code. Safe Drinking Water means Safe Drinking Water Act, Statute 88, 1661, 1974, Title 42, U.S. Standard Code Authority 300F, as amended Safe Drinking Water Amendments of the 1977, 91 Statute, Title 42, U.S. Standard Code Authority, Safe Drinking Water Amendments 1986, and the Safe Drinking Water Act Amendments of 1996 and regulations adopted under those acts. Person including in political subdivision, department, agency, instrumentality, state with the United States Department, agency, instrumentality thereof, legal entity defined as a person. Section 159 Revised Code, any other form of the business or organization any of the recognized laws of the state. Brine means any saline geological formation, water resulting from obtaining or produced connecting the exploration, drilling wells, stimulation, producing oil, gas, or plugging well. Water of the state means that streams, local lakes, ponds, marshes, watercourses, waterways, springs, irrigation systems, drainage systems, other bodies of the water surface, underground, natural, or artificial that is situated wholly and partially within the state or within its jurisdiction, except for the private waters that do not combine or in effect joint with natural surface underground waters, except for the Mississippi well means well that meets the following criteria: well drilled completed before January 1st, 1980, located in an unglaciated part of the state, was completed in a reservoir deeper than the Mississippi Big Engine sandstone areas underlain by Pennsylvania Permian stratigraphy and the Mississippi Berea student stone areas directly under the Permian stratigraph. It is used to provide oil and gas domestic use, except for the domestic well meets all the following criteria: as own and owner surface state of a tract around which the well is located is used primarily to provide gas or owner's domestic use. It's located more than 200 feet horizontal distance for the inhabited private dwelling housing other than inhabited private dwelling house located on the tract on which well is located. It's located more than 200 feet horizontal distance to any public building that may be used in place of resort, assembly, education, entertainment, lodging, trade, manufacture, repair, storage of traffic, and occupancy by public. Why urbanized area means any area where the well production facilities are located with a municipality corporation within the township has an unincorporated population of more than 5,000 in most recent federal decennial census prior to issuance of permit well of the production facility. Well stimulation well means with the process enhancing well productivity, including hydrofracturing operations. Double A, production operation means operation activities all related to equipment, facilities, other tract structures may be associated with the exploration, production of oil, gas, other mineral resources regulated by the under chapter, including operation activities associated with the site preparation, site construction, access, road construction, well drilling, well completion, well stimulation, well site activity, reclamation, and plugging. Production operations also include the following: pumping equipment facility with the production, preparation, hydro gas, and liquids for transportation or delivery, process extraction, recovery, lifting, stabilization, treating, separation, production, process, storage, waste disposal, measurement, hydrocarbon, gas, liquid, and liquids included related equipment and facilities, process related equipment and facilities associated with the production of gas, lift, gas injection, fuel, gas supply, well drilling, well stimulation, well completion activities, including dike pits, earthians, other impounds used to temporary storage of fuel, fluids, and waste substances associated with well drilling, well stimulation, well completion activities. Equipment facilities, well pad, other locations used for the transportation, holding, relation, recycling, temporary storage, permanent management, processing, and treatment of any equipment, material, byproducts, other substances of the operation. Well pad may be used, reused, the same, and or another operation over the well pad, disposed in accordance with applicable laws and rules adopted under them. Annular overpressurization means accumulation fluids of the annular sufficient pressure to allow mitigation of the annular fluids into the underground source of drinking water. Orphan well means a well that has not been properly plugged in its land surface restored in accordance with the chapter rules adopted under it, which either the following apply: owner of the well is unknown, deceased, cannot be located, the well is abandoned, the owner well has abandoned the well, there's no money available to plug the well in accordance with the chapter the rules under it apply under it. Temporarily inactive well means the well has been granted temporary inactive status under section 1509-062 revised code. Material substantial violation means any of the following: failure to obtain a permit, drill, reopen, convert, plug back, plug a well on this chapter, failure to obtain, maintain, update, submit proof of the insurance coverage required on this chapter, failure to maintain, obtain, submit proof of surety bond required on this chapter, failure to restore disturbed land surface required in section 1509-072 revised code, failure to reimburse oil, gas, well fund pursuant final order issued under section 1509-071 revised code, failure to comply with finally non-appealable order of the chief issued under section 1509-004 revised code, failure to submit the report test result of the document is required in chapter of the rules adopted under. FS server has the same meaning as 574901 revised code. Horizontal well means a well drilled with the production of oil, gas, well bore reaches horizontal, near horizontal position in Point Pleasant, Utica, Marcellus formation well, stimulated horizontal well does not include stratigraphic well Well pad means an area that is clearly prepared. Drilling one or more horizontal wells, stratigraphic well, borehole drilled with a track solely through the conduct of research testing surfaces like geology, including porosity, permeability. Stratigraphic well does not include geotechnical or soil borings or borehole drilled in seismic shot or mineral mining of industrial minerals or coal. Let's go to the next one. All right, 15092, Division Oil Gas Resource Management Chief Oil Gas Well Fund. This is hereby created by the Department of the Natural Resources of the Division of Oil Gas Resource Management, should be administered by the Chief of the Division of Oil Gas Resource Management of the Division, sole of the exclusive of the authority, regulate, permit, locating, spacing of the oil, gas wells, production, operation, state, except for those only activities regulated with the federal laws which the oversight has delegated to the Environmental Protection Agency. Activities regulated under Section 611102, 611128 to 6111.028 with the revised code of regulation of oil gas activities, and in the matter of the general statewide interest require a uniform statewide regulation chapter rules adopted with the constitute of the comprehensive plan with respect to all aspects of locating, drilling, well stimulation, completing, operating oil, gas wells, and within the state would include site construction and restoration permitting related to those activities, disposal waste for the wells, in order to assist the division further with the sole of the exclusive authority established in this section. Chief may enter the cooperative agreements with the other state agencies for advice and consultation, including visitation of the surface wells, location of the well on behalf of the division. Surface cooperative agreements do not confirm other agencies may any authority to administer and enforce a chapter of the rules adopted under it. In addition, such cooperative agreements shall be construed to dilute, diminish the division sole of the exclusive authority established in this section. Nothing in this section affects the authority granted with the Director of Transportation and Local Authorities, Section 723.01 and 445.13.34 of the revised code. Provided that the authority granted under this section shall not be exercised in a manner that discriminates, unfairly impeds, or obstructs oil gas activities in the operation regulated under this chapter. Chief shall not hold any other public office, nor shall the chief be engaged in occupant business that may interfere with the inconsistent with the duties of the chief. Money collected with the chief pursuant of section 1509, 06, 0601, 0602, 0701, 13, 22, 222, 228, 3450, and 02 of the revised code. All civil penalties paid under section 1509, 33 revised code, notwithstanding any section revised code relating to distribution credit lines, fines, and violation of the revised code. All fines imposed under subdivision A and B of section 1509.99. Revised code fines imposed under section under division C and D is section 1509.99. Revised code for violation prosecuted by the Attorney General and for violations prosecuted by the prosecuting attorneys do not involve transportation of brine by the vehicle shall be deposited with the state treasury with the credit over the oil and gas well of the fund with the hereby created to here fines imposed under this division C and D section 1509.99. Revised violations prosecuting attorneys involved with the transportation of brine by vehicle penalties and vehicles and penalties associated with the compliance agreement entered with the pursuant with the chapter shall be paid with the county treasurer of the county in which violation occurred. The fund shall be used solely exclusively for the purpose enumerated with the Division B with the Section 1509.071 for the revision code of the expense of the division associated with administrative of the Chapter 1571 revised code rules adopted under them for the expense of the critical necessary protection of human health and safety of the environment related to oil and gas production in the state. Expense of the division with excess of the monies available to the fund should be paid with the general revenue operations of the department. Alright, surface location of wells, 1509.21. Surface location of the new well tank battery with wells shall not be within 150 feet of the occupied dwelling located in the urbanized area unless the owner's land on which occupied dwelling land located consistent with the writing surface location well, a tank battery, or a well less than 150 feet of the occupied dwelling, with the Chief of the Division of Oil and Gas Resource Management approve of the written consent of the owner. However, the Chief of the not approve of the written consent of such owner with the surface location new well with the tank battery over the well will be within 150 feet as an occupied dwelling is located in an urbanized area. The surface location of the new well should not be within 150 feet of the property line parasol with the not drilling unit and with a well parcel of land located in the urbanized. The directional drilling will be the direct drill with the new wells unless the owner's parcel of land consisting with a writing of surface location well less than 150 feet with the property line parcel of land. Chief approve of the written consent of the owner. However, the chief does not approve of the written consent such an owner or surface location of the new well will be less than 100 feet from the property line. The owner parcel of the land is not drilling unit well. The parcel of land is located at the urbanized or directional drilling unit will be used. See, the surface location new well should not be within 200 feet of the occupied dwelling located in the urbanized area located with the land becoming the dwelling unit well pursuant with the mandatory pooling order issued in section 1509-27 of the revised statute enclosed unless owner of the land of the occupied dwelling is located consistent with the writing and the surface location of the well distance is less than 200 feet from the occupied dwelling. However, the owner of the land is occupied the dwelling, provided the written consistent with surface location that it shall be within 100 feet of the occupied dwelling. If the applicant cannot identify the owner of the land responsible for the attempts by applicant to the contact with the owner, applicant may submit with the affidavit the chief of the testing with such an unidentifiable owner of the owner response, such as unresponsible owner of the attempts applicant with the contact owner include written requests for the reduce the distance of the location of the well occupied dwelling of at least 200 feet. But the chief of the receipt of the such affidavit of written request, chief shall reduce the distance of the location well of the occupied dwelling to a distance not less than 100 feet, except as otherwise provided in Division L of this section. Surface location of the new well shall not be within 150 feet of the property line parcel of the land located in the urbanized area that has been part of the dwelling unit with a well pursuant with the mandatory pooling order issued under section 1509-27 of the revised code. Unless the owner of the land consistent with a written surface location of the well distance less than 150 feet from the owner's property line. However, the owner of the land provides such written consent, surface location of the well should not be within 75 feet of the property line of the owner's parcel of land. If the applicant cannot identify the owner of the land is not responsible for the attempts by the applicant with the contact of the owner. Applicant with a submit affidavit the chief of the testing with the unidentifiable the owner who is such unresponsible for the owner and attempts to applicant with the contact with the owner include a written request of the reduce of the distance of the location of the well of the property line owner parcel of land less than 150 feet with the chief of the receipt of the affidavit with the written request the chief shall reduce the distance of the location well of the property line and distance not less than 75 feet. Surface location with a new light tank battery well shall not be within 150 feet of the occupied dwelling located with the urbanized located land of the become of the dwelling unit well pursuant with the mandatory pooling order issued under section 1509-27 of the revised code unless the owner of the land which of the occupied dwelling is located consistent with the writing location tank battery distance is less than 150 feet from the occupied dwelling. However, the owner of the land of the occupied dwelling located with it provides such written consent with the location of the tank battery shall not be within 100 feet of the occupied dwelling. If the applicant cannot identify the owner of the land is not responsible to attempts by the applicant to contact with the owner. The applicant submitted to the affidavit the chief of the testing unidentifiable the owner of the unresponsible the owner attempts with the applicant and to the contact with the owner included for the written request to reduce the distance location of the tank battery occupied dwelling less than 150 feet. If the chief receives the affidavit the written request the chief of the reduce the distance of the location tank battery occupied dwelling to the distance not less than 100 feet, except as otherwise provided in subdivision L of this section. Location of the new tank battery well not should be even 75 feet of the property land of the parcel located with the unurbanized area with it becoming part of the dwelling unit of the well pursuant with the mandatory pooling order issued under section 1509-27 of the revised code. Unless the owner of the land consistent with the writing and location tank battery distance is less than 75 feet with the owner's property line. However, the owner of the land provides such for the written consent with the location of the tank battery shall not be within the property line of the parcel of lands. If the applicant cannot identify with the owner of the land is not responsible for two attempts by the applicant contact with the owner. The applicant may submit with an affidavit the chief of the testing with the identifiable owner of such unresponsible the owner of the attempts with the applicant to contact owner indicating written request for due the distance of the location of the tank battery property line owned parcel land to less than 75 feet. If the chief receives such an affidavit then a written request chief will reduce the distance of the tank battery from the property line provided the tank battery shall not be within the property line of the owner's parcel land. For purpose of subdivision C through F, a written consent for the owner of the land may be provided with the following copy of the original lease agreement with a record for the official county record of the county with the occupied dwelling with the property located with the expressly provided with the reduction in distance of the location well of the tank battery applicable to the occupied dwelling and property line. Copy of the deed serving of the oil, gas, mineral rights of was applicable for the owner parcel of land with the recorded in the office of the county recorder of the county with the property line. Property is located expressly provided with the reduction distance location well tank battery is applicable for an occupied dwelling or a property line. 3. A written statement consistent with the proposed location of the well tank or battery is applicable provided with the chief for the purpose of the division. G3 of the section, applicant shall submit a copy of written statement to the chief. H. How for areas that are non-urbanized, surface location of the new well should not be within 100 feet of the occupied private dwelling or public building that may be used as a place of the assembly, as education, tournament, lodging, trade, manufacturer, repair, storage, or occupants by the public subdivision does not apply with the building or other structures incidentally to agricultural use of the land in which the building or other structures located unless the building or other structures are occupied with the private dwelling of the retail trade. The surface location of the new well should not be within 100 feet of any other well. However, the applicant may submit a written statement of request for the chief of the authorized new well located with a distance less than 100 feet from another well. The chief will receive the written statement. The chief may authorize a new well located 100 feet from another well if the chief determines the applicant satisfactorily demonstrated with the location of the new well with a distance of less than 100 feet. Another well with the necessary to reduce the impacts of the owner on the land which the well is located within the surface of the land on which the well is to be located. J. For areas with the non-urbanized location, new tank battery as well should not be within 100 feet of the existing inhabited structure. K. Location of the new tank battery well should not be within 50 feet of any other well. Location of the new well may be a new tank battery well should not be within 50 feet of the stream, river, watercourse, water well, pond, lake, or other body of water. However, the chief of the mayor authorized a new well on a new tank battery located at a distance less than 50 feet from the stream of the river, the watercourse, water well, pond, lake, other body of water. Chief determines of the reduction distance necessary to reduce the impacts of the owner on the land where the well and the tank battery of well is located to protect the public safety of the environment. The surface location of the new well tank battery will not be within 50 feet of a railroad track or a traveled portion of a public street with a road or highway division, regardless of whether the public or street, road, highway has become drilling units of the well pursuant with the mandatory pooling order issued in 1509-27 of the revised statute. And a new oil tank shall not be within 3 feet of another oil tank. The surface location of mechanical separation shall not be within any of the following: 50 feet of the well, 10 feet of the oil tank, 100 feet of the existing inhabited structure. P. A vessel is equipped to touch or of the contents of vessel that being heated should not be with any of the following: 50 feet of the oil production, 50 feet of the well, 100 feet of the existing inhabited structure, and contents of vessels are heated by direct fire heat, 50 feet of a mechanical separator. Or Section 1509.022. Location well used in the direction of drilling. Except to provide in Section 1509.021 revised code, the surface location of a new well that will be drilled using the directional well may be located on parcel land that is not in the drilling unit of the well. 1509.003 Administrative Rules. Chief of the Division of the Oil and Gas Resource Management shall adopt or design with amendment of the according to the Chapter 119 Revised Code Rules of the Administration and Implementation Enforcement. As the chapter of the rules shall include identification subject of the Chief of the address with the attaching terms and conditions to a permanent respect for the well and production facilities of the well located within within an urbanized area with respect for the horizontal well production facilities associated with the horizontal well. Subject shall include the following: specific concerning drilling operation well, protecting public and private water supply, including amount of water used and source of the water, fencing, screening surface facilities of the well, contaminating disposal of the drill production waste, construction access roads to the proposed drilling and operation of the well, noise mitigation purpose of the drilling of the well, operating the well, excluding safety and maintenance operations. No person shall violate any of the rule chief adopted under the chapter. B1. Any order issuing, denying, modifying permit notice required to be made by the chief pursuant to the chapter in compliance with the Chapter 119 Revised Code, except personal services may be in lieu and services by mail. Every order issuing, denying, modifying a permit under the chapter describes the shall be considered the junction order for purpose of Chapter 119 Revised Codes, Division B1 of the section does not apply with the permit issued under Section 1509.06 Revised Code. Whether notice of any of the person of the chapter notice shall be given in order to meet with the requirements of law. C. The chief of the chief to authorize representative at any time enter the lands in public and private for the purpose of administrative the enforcement of the chapter rules adopted with the order made there under terms and conditions, permits, regulation, registration certificates issued there under, and may examine a copy of the records pertaining to the drilling, conversion, operation well for injection fluids and logs required in Division C of subsection 1509.223 of the Revised Code. No person person shall prevent, hinder the chief of the, or chief authorized representative of the person performance of the official duties. If entry is prevented with the hinder of the chief the authorized representative may apply with the court common pleas. It may issue with an appropriate inspection warrant necessary to the purpose of the chapter of the court's territorial jurisdiction. The chief may issue with the enforced chapter's rules adopted there under terms and conditions permitted to issue thereunder. He has such an order considered for the injunction order of the purpose of Chapter 119 Revised Code. No person shall violate any order of the chief issued under this chapter. No person shall violate a term, condition, permanent registration certificate issued under this chapter. Orders of the chief denying, suspending, revoking registration certificate, proving the denial approval of the application for provision, registered transporter plan for the disposal of the implement administered in 4th Division A, Section 1509, 224, Section 1509, 22, 222, 223, and 225, and 226 of the revised code pertaining to the transportation of brine by vehicle. Disposal of the brine is transported and not injunction authorities orders pursuant to Chapter 119 revised code. The chief shall issue with such orders under divisions A and B of Section 1509, 224 revised code as appropriate. Alright, 1509-031, electronic submission of oil gas documents. Notwithstanding any other provision of the law contrary other than statement of production, chief of the division of oil gas resource of the management may require the electronic submission applicant report test results fee of the document with the required to submit under this chapter. The chief of the may require submission of a statement of production to be made electronically regardless of well type, the number of the wells owned. For good cause, a person may request it to be excluded for any requirement to make electronic submissions under Division A section other than requirement to submit a statement of production electronically. The chief shall be established procedure for a form which a person may request such exclusion. Enforcement injunction against violation. The chief of the division of oil gas resource management, chief authorized representative of the chapter rules and terms and conditions permits of the registration certificates or adopted issued pursuant thereto, except the peace officer for the defined section 293501 in revised codes may arrest the violation chapter involved in the transportation of brine by vehicle. Enforcement authority. The chief includes the authority to issue and compliant notice enter with an compliance agreement. The chief of the authorized representative may issue with administrative order to issue subject to the chapter of the rules adopted under it, a violation of chapter rules unadopted under it in terms and conditions permitted issued under the registration certificate required in chapter orders issued under this chapter. 2A. If the person who is required to submit the test or the report test result of the word documented by the chapter of the rules adopted under the submit with the request extension of the time of the submit of the report test result of the document of the chief prior to the day of the report test result of the fee of the document is due, with the chief may grant an extension of no more than 60 additional days of the original date with the report test result for your document is due. If the person is required to submit a report test fee and test result fee with a document with the chapter rules adopted the fee, it fails to submit with the report test result fee, the document before any of the day of the which is due, with the chief if it's not granted the extension time under section B2A of the section, chief shall make reasonable attempts to notify the person failure to submit with the report test result of the fee and document. If the person who receives such a notification fails to submit with the report test result fee document on before 30 days after the date which the chief is notified to the person, chief may issue an order under subdivision B3 of this section. Chief may issue an order finding the person has committed material substantial violation. Chief may order immediately may suspend drilling operation plugging activities that are related to material substantial violation, suspend and revoke unused permit after finding either the following: person failed to comply with the order of subdivision B3 of the section final and a non-appealable. Person has committed material substance of violation causing, engaging, maintaining condition, activity of the chief that determines present imminent danger of the health and safety of the public that results likely to result in immediate substantial damage of the natural resources of the state. Chief may issue an order in subdivision C with a section prior notification. Reasonable attempts to notify if the person has failed. If the person is currently in material breach of the print order in such an event, notification shall be given as soon as they are half practicable. No later than 5 days after the issuing of the order of the subdivision C section, the chief will provide a person an opportunity to be heard and present evidence that only following apply. One of the following applies. If activity does not present imminent danger of public health and safety, not likely to result with immediate substantial damage to the natural resource, required records, reports, and logs have been submitted to the chief, and if the chief, after considering evidence presented by the person under section D2A of the section, determines the activity does not present such a threat, or required reports or logs have been submitted under section D2B of the section, the chief shall revoke the order. Person may appeal an order of the court or common pleas of the county in which the activity subject of the order is located. Chief may issue the bond forfeiture order pursuant to Section 1509.071 Revised Code failure to comply with the final non-applicable order issue compliance agreement entered under this section. Chief may not notify the drilling, contractor, transport, or service company of the other similar entity with the compliance status of the person over the subject of the chapter of the rules under it. If the person fails to comply with the prior enforcement action of the chief may issue a suspension order with a prior notification, but in such an event, the chief shall give the notice thereafter practicable, no later than 5 calendar days after the issuance of the order. Chief shall provide in person with the opportunity to be heard present, edited with the record reports, required records, reports, and logs have been submitted to the chief of the consider the evidence presented that the person can determine the requirements that has been satisfied by the chief to revoke the suspension order. The person may appeal the suspension order to the court or come and plead with the county in which the activity subject to the suspension order is located. Prosecution attorney of the county with the attorney general upon request of the chief may apply with the court common pleas in the county in which any of the provisions, chapter, any of the rule, term, and condition of the permanent registration certificate orders are adopted, issue, and pursuant of this chapter have been violated or temporarily restraining order, preliminary injunction, or permanent injunction restraining any person from such violation. 1509.041 database listing final non-appeal orders issued violation to be accessible to the public. Chief of the Division of Oil and Gas Resource Management shall maintain a database Division of Oil and Gas Resource Management website that is accessible to the public. The database list each final non-appealable order with a material substantial violation of this chapter. List shall identify the violator, date of which the violation occurred, and the date of which the violation was corrected. Alright, permit required to drill, reopen, convert, or plug back a well. No person shall drill with a new well, drill with the existing well any deeper, the reopening of the well, convert any of the well, any of the other original person, or to plug back a well to the source supply different with the existing pool without having the permit to do issue with the chief of the Division of Oil and Gas Resource Management until the original permit or photostatic copy of there has been posted displayed with the conspicuous, easily accessible of the well site with the name and the current address, telephone number, permit holder, the telephone number to fire an emergency medical services maintained on the posted permit, or with a copy of the permit and a copy continuously displayed with the manner of the times during the work authorized by permit. Stratigraphic wells. Except for the otherwise provided in this section, the chapter rules adopted under the stratigraphic wells, regardless of whether the section in this chapter such rules refer to the well, oil, gas production to the owner or to an owner. That was Section 1509.06 of the revised code applicable to the permit the drill stratigraphic well shall be with the form prescribed by the chiefs of the Division of Oil, Gas, Resource Management shall contain the information required in Section 1509.06 of the revised code is applicable for the person shall not submit more than 7 applications per year for the permit the drill stratigraphic well unless otherwise approved by chief. Allowing the following do not apply to the stratigraphic well: 1509.62, 1509.11, and 1509.24. The rules adopted under relative to the minimum acreage requirements for the drilling unit. Ohio Administration Code 1501.92, 93, 94, 95, 97. Stratigraphic well may be assigned, otherwise transferred. Notice of the such assignment, the transfer should provide and chief of the form prescribed with the provided chief sign both of the assigner and assignee, or by both transfer and transferee. Surface location stratigraphic well should not be within 150 feet of the property line on the track which well is drilled. Stratigraphic well should be plugged not later than 1 year after drilling commencement on the well, unless either of the following apply. Subdivision G2 of the section owner and stratigraphic well applied with a 1 year period permit converted with the well to another use of subject regulation in Chapter 611 Revised Code. Subdivision G3 of the section owner and stratigraphic well executes file with the division form prescribed with the provided for the division of the financial assurance and payable to save the amount approved the chief of the approval equal to the grade of the estimated cost of the plug of the well reclaimed with the associated well site. Financial assurance shall be in addition but not in lieu of any surety bond, any financial assurance required under the law. Financial assurance may be in the form of cash surety bonds in the names of such obligee and execute with the surety company authorized to do with the business in the state. If the owner and stratigraphic well apply with the permit to convert with the well in accordance with the G1A of the section fails to comply with the conversion of the well to another 2 year after drilling commenced with the stratigraphic well, owner should immediately plug the well in no later than 30 days of the expiration of the 2 year period to execute with the file with the division financial assurance according with the division G1B of this section. If the owner and stratigraphic well executes files of financial assurance of the division according with the G1B of this section, stratigraphic well shall be plugged no later than 5 years after the drilling commencement of the well, unless the stratigraphic well lawfully converted to another subject of the regulation chapter under this chapter or chapter 6111 of the revised code for within the 5-year period, except otherwise provided in section 1509.12 of the revised code. Stratigraphic well plug no later than 1 year after the issuance of final non-appealable order denying and affirming the denial of the application of the permit to convert the well to another such regulation under this chapter or 611.1 revised code. Chief may forfeit order with the total amount of the financial assurance executed the final filed under subdivision G1B of the section. Chief funds of the owner well is non-compliance of the section. Chief is to ensure that the order contains the fines, facts supporting forfeiture set forth. Violation given the rise of the order. Chief may issue money obtained with the forfeiture plug with the stratigraphic well is not plugged, has been not been completely converted with according to the time specified on the subdivision G of the section. Stratigraphic well has not been plugged in, is not completely converted, and it may be plugged using procedures established in section 1509.7071 revised code pertaining to orphan wells. Stratigraphic well owner financial assurance of the form of surety bond of the division. Chief of the issue ordered under section H1 of this section of the chief of the issue of an order bank of the surety company with the informing banking company option with the plug of the lieu of the forfeiture. I1 subdivision I2 and 3 section owners of stratigraphic well may elect to sole discretion designate the following to be confidential business information not subject to disclosure under any provision of the law for the period of 5 years, the time of the dwelling commenced on the stratigraphic well. Date on the research of the subsurface geology obtained with the stratigraphic well, any of the following with the otherwise required submission under this chapter rules adopted under two with an order. Chief, any term condition report issued by the chief of the report document records, the owner of stratigraphic well, upon request of the chief, shall disclose the data of the research of the subsurface geology obtained with the stratigraphic well. The chief, if it be necessary, to respond with investigate harm, potential harm to public health and safety of the environment, including potential damage in subsurface formations. However, such as the data remains confidential. Business information shall not be disclosed by the chief of the non-public record subject to the inspection copying under section 149.43 revised code till expiration of 5-year period. The owner of stratigraphic well shall submit any of the report document records required for the subdivision chapter rules under any other chief of the term and condition permits issued. Chief, however, any such report documents and records designated with the confidential business information will remain confidential. Business information shall not be disclosed by the chief of the not a public record subject to inspection copying under section 149.43 revised code till expiration 5-year period. In J, the chief may post the surface location of stratigraphic well on the division's website. Alright, application permit to drill, reopen, convert, plug well back. Application of the permit to drill with a new drill with the drill existing well deeper to reopen a well with a converted well, any of the original purpose of the plugging back well with a different source of the supply with the included associated production and water operations shall be filed with the chief of the division of oil and gas resource management upon such form. The chief of the scribe shall contain the following: applicable, the name and address of the owner of the corporation, name and address of the statutory agent, signature owner, authorized agent signs application with the accompanied with a certified copy of the appointment of such agent with the name and address of all the persons holding the royalty interest of the tract with which of the well is located, the drill with the proposed drilling unit, location of the track of the drilling unit, well located with the drill identified with the section lot number, the city, village, township, and county designation, well by the name and the number, geological formation tested, name of the proposed towel, the depth of the well with the injection of the liquid identified with the geological formation, with the injection zone composition liquid to be injected, and so on the type of the drilling equipment to be used, identification of the best owner's knowledge of each of the proposed surface of the groundwater. The surface of the water will be used for the production and operation of the well. Identification of each proposed source of the water, indicated that the water will be drawn with the lake area, the watershed of the Ohio River, the watershed addition of the owner shall provide with the best of the owner knowledge proposed estimated rate of volume of the water withdrawal with the production operation. Recycled water will be used for the production operation. The owner shall provide with the estimated volume of recycled water to be used. The owner shall be submitted with the chief of the update with the information required in subdivision of this section. If any of the formation information changes before the chief of the issues of the permit of the application, except for provided in the A8C of this section with the application of the permit of the drill new well on an urbanized area with the result of sampling of the water wells of 300 feet with a proposed well prior to the commencement of the drilling. In addition, with the owner shall include a list of identifiable location of each water well where the owner of the property water located with the denied with the owner acts with the sample of the water well with the sampling and shall conduct with accordance with the guidelines established and best management practices of pre-drilling water sampling and effects for the time of the applicant submitted with the division shall furnish guidelines upon request shall make available the division website with the chief of the determined with the condition proposed well site with the warrant of revision shall the chief of the provide with the distance established for the division purpose of the pre-drilling water sampling. C. For the application permit, the drill of a new horizontal well with the water resulting sample of water within 1,500 feet of the proposed horizontal wellhead prior to the commencement of the drilling. Additional the owner shall include the list of the identifiable location each of the water well of the owner of the property water well located at the night of the owner acts of support sample the water well with the sampling conducted in accordance with the guidelines established with the best management practice of the pre-drilling water sampling in effect for the time when the application is submitted to the division shall be furnished with the guidelines upon when the request shall make it available to the division's website. Chief determines the condition proposed well site with a warrant revision. Chief may provide the distance established with the division for purpose of the pre-drilling watering sampling. 9. For application for the permit to drill of a new well within an urbanized area with its warrant statement, the applicant will provide notice of the regular mail with the applicant with the owner of each of the real parcel of the real property located within 500 feet of the surface location of the well. Executive Authority, Municipal Corporation, Board, Township, the trustee of the township of the aquifer of which of the wells located with the ditching with the notice shall contain the statement and inform the owner of the real property which required the receipt of the notice under subdivision A9 of the section within 5 days of the receipt of the notification. Owner is required to provide a notice of the under section 1509-60 of the revised code of each of the residents of the occupied dwelling is located with the owner of the parcel of real property notice shall be contained with the statement. Applicant with the has been filed with the Division of Oil and Gas Resource Management, identified with the name of the applicant, proposed well, the location, and include with the name of the address of the division contained with the statement. Comments regarding the application may be sent to the division and the notice proposed with the man delivery regular mail with the identified with the owners of the parcel of the real property determining the tax record with the municipal corporation county of the parcel of real property located from the date with the notice of plan with the restoration of the land surface disturbed by the drilling operation plan shall provide with the compliance restoration requirements of subdivision A, section 1509-072 revised code. Any rules adopted by the chief lieutenant with the restoration. 11A with the description of the name and the number of the county township with the municipal corporation, roads, streets, highways applicable anticipated for the use of for access of the egress of the well site. For application permit with a horizontal well with a copy of the agreement with the concerning the maintenance safety of the road and street highways with the described in subdivision A11A section enter for the responsible term of the public official with the legal authority to enter in such of the maintenance agreements with each of the township, county, and municipal corporation and applicable to each of the such road, street, highway located at with the affidavit the form provided described with the chief of the testing with the owner with the attempted with a good faith to enter with the agreement under subdivision A11B with this section with the applicable public official with each of the county, township, with the municipal corporation not agreeable to execute such of the relevant information of the chief prescribed without a rule. Each applicant should be accompanied with a map on a scale with a not to smaller than 400 feet with an inch of the prepared with the Ohio registered survey showing with the location of the well with the containing such for the other tab of the prescribed with the chief. If the well is to be located with the excavation with the working of the mine with the map also include with the location of the mine, the name of the mine with the name of the person on the operating the mine. Chief calls of the copy of the weekly circular prepared for the division to provide with the county engineer. Each county contain with the activity of proposed drilling activity weekly circular which shall contain with the manner prescribed with the chief of the name of the applicant with the permit to location of each of the well proposed well with the information required by the division A11 with the section additional information from chief prescribed with addition with the chief of the promptly shall the transfer of the electronic copy to the method is not available to the municipal corporation, township, or township's copy to be with the regular mail with the drilling permit the applicant will declare or legislative authority municipal corporation or to the clerk of the township at the village of the well of the proposed well or is to be located with the legislative authority municipal corporation or to the board of trustees township trustees have asked to receive the copy of such applicant with the appropriate clerk with the chief of the accurate and current electronic mailing addresses. C1. Except for the provided in C2 with the section, chief of the shall not issue with a permit less than 10 days after the date of the filing applicant with a permit unless within upon reasonable cause of the chief waives with the period of the request of the expedited review of the file within the section. However, the chief shall issue permits 21 days after the filing applicant if the chief denies the applicant over the order. If the location of the well proposed well will be or within an urbanized area, the chief shall not issue with a permit in at least 18 days after the date of the filing applicant with a permit unless of the reasonable cause shown with the chief of the waive of the period of the chief and the chief of the discretion of the grants requested for the expedited review. However, the chief of the issue of the permit of the well proposed well with the urbanized area within 30 days of the filing applicant unless the chief denies the applicant by order. An applicant may file with the requested chief of the expedited review of the permit or application over the well is not or the not to be located with a gas storage reservoir protective area with the reservoir protective area to define in section 1571.01. If the well is to be located with a coal-bearing township, the applicant shall be accompanied with the affidavit of the landowner prescribed in section 1509.08 revised code. Addition with a complete application from the permit to meet for the requirement of the section with the permanent fee within the section request for the expedited review. The accompanying Simply non-refundable filing fee of $250 upon filing request for this expedited review. The chief of the hotel of the county engineer of the county of the well is to be located with notified of the filling permanent application request for the expedited review with the telephone and other means of the judgment. Chief of the will privately provide timely notice for the applicant with the request. Chief of the issue shall issue with a permit within 7 days of the filing request time of the chief of the denial of the applicant or the not receiving of the provision section governing expedited review of the permit application. Chief of the refuse of the accept of the request of the expedited review. The chief judgment acceptance of the request would prevent the issuance within 21 days of the filing permits for the application and pending as well. The shall be drilled in accordance with the plan, sworn statement, and other information submitted with the approved application. If the chief shall issue the order denying the permit, if the chief finds that a substantial risk to the operation will result with a violation of the chapter of the rules adopted under the present imminent danger of public health or safety damage of the environment, provided the chief finds of the term of the condition permanent with a reasonable expected for such violation, chief shall issue the permit subject to the term of the conditions, including if applicable the term of the condition regarding subjects identifying the rules under section 150903 of the revised code. The issuance permit shall not be considered order if the chief is supposed to the notice each of the permit has approved under the section of the division website no later than 2 business days after the applicant permit has been approved. Each applicant with a permit requiring 150905 of the revised code, except for the applicant with a well drill with the reopened purpose of section 150922 of the revised code, shall be accompanied with the non-refundable fees as follows: $500 per minute to conduct the activity township with a population fewer than 10,000, $750 for the permit conducting activity township population 10,000 or more but fewer than 15,000, $1,000 for a permit to conduct activities in either of the following: township population $15,000 or more, a municipality corporation regardless of the population. Application with permit requires mandatory pooling an additional $5,000 for purpose of calculating the fee for the population with determined use of the more recent federal decimal census. Each of the application revision reassurance of the permit accompanied with a non-refundable to $250 prior to the commencement of the well pad construction of the prior of the issue of the permit. The drill with the proposed horizontal well, proposed well that is located with the unurbanized area of the division. Conduct site review of the identified with the evaluate site specific term and condition to be attached to the permanent site of the review representative of the division shall be considered the fence over the screen with landscape requirements of the similar structure commencement of the community in which well was proposed located with the term and condition attached with the permit that include with the establishment of the fencing screen with the landscaping requirements of the such facility with the proposed well, including tank battery well of the well. Prior to the issuance of the permit, drill of the proposed the division should conduct the review and identifying and evaluate any site specific term and conditions that would be attached to the permit proposed well located 100-year flood plan, 5-year time when the ravel associated with the public drinking water supply. Permit shall be issued with the chief of the accordance with the chapter of the permit issued under the section of the well or located in an urbanized area. The area shall be within 12 months of the other permits under the section shall be within 24 months. An applicant permit is applicable shall be submitted. The chief will update with the information required in subdivision AAA with the section as the information changes for the commencement of the production operations. K. A permittee or permittee's authorized representative shall notify the inspector of the division at least 24 hours in another time period agreed for the chief of the authorized representative prior to commencement of the well pad construction of the drilling, reopening, converting well stimulation, or plug back operations. Alright, 1509-067, the request to revise existing track upon an existing producing idle well. An owner well who has been issued a permit under section 1509-06 revised may submit with the chief of the division oil gas resource management form prescribed by the chief of the request to revise existing track upon which existing producing idle well. The chief of the shall adopt may with the amendment of the residing rules under section 1509-03 revised code necessary with the administrator of the section of the rules least stipulate with the information included with the request form with the established fee for the person submitting the request, which fee with the not exceeding $250. The chief shall approve the request submitted under the section listed that would result in the violation of chapter rules adopted under including provisions establishing spacing minimum acreage requirements. Temporary inactive well status. An owner of the well that has not been completed, the well has not been produced for 1 year after the completion of existing well ship, not a horizontal well, has no reported production for the 2 consecutive reporting periods that required reported in accordance with 1509-11 the revised code. Existing plug well in accordance with 1509-12 of the revised code is obtained temporary inactive well status in accordance with the section with the performer and another activity regarding well that is approved with the chief of the division oil gas resource management. If the well is reported annual production less than 100,000 cubic feet of the natural gas, 15 barrels of crude oil, or a combination thereof with the treatment, they require owner well to submit with the applicant with temporary and active well status under the section for the well. In order for the owner to well to submit with the applicant the temporary and active well status of the well under the division with the owner and the well shall be even compliant with the chapter of the rules adopted under it and the terms and conditions of the permanent well, the applicable orders of the chief. The applicant with the temporary and active status submitted with the chief of the form of the prescribed provided with the chief of the containing with the following: the owner's name and address of the corporate, if the owner's corporation, the name and address of the corporation statutory agent, signature of the owner and the owner's authorized agent of the authorized agent applicant. The applicant should be accompanied with a certified copy of the appointment as such an agent. The permanent number signed with the well. If the well is not signed with a permanent number, the chief assigns with the permanent number to the well with a map with a scale with not smaller than 400 feet with an inch show the location well with the tank battery include the latitude, longitude of the well contains all of the data required by the chief of the demonstrator of the well with forfeiture utility applicable with a viable payable plan to utilize the well with a reasonable period of time. The demonstrator of the well poses no threat to health or safety of person, property, or the environment. Any other relevant information chief prescribes by the rule. Chief may waive any requirements established in B126. The second division, oil, gas, resource management, possesses the current copy of information documentation required to applicable division. See, upon receipt of the applicant, the temporary and active, the well shall have the chief of the review of the application. She will either deny with the application issue with the order approve of the application. The chief shall approve applicant only with the chief determines the well with the subject of the applicant poses no threat to the health and safety of the person, property, or the environment. Chief of the approve of the application. Chief of the notify of the applicant of the chief of the approve of the upon the receipt with the chief of the approval of the owner shall shut within well with the empty with all the liquid gas of the storage tanks, pipelines, and other equipment associated with the well. With addition of the owner shall maintain a well with the other equipment associated with the well, serve at the location of the well, manner of the prevent hazards to the health and safety of the people of the environment. Owner shall inspect the well at least every 6 months and submit it with the chief within 14 days of the inspection record of the inspection form prescribed provided by the chief. No later than 30 days to the expiration temporary and active well status for the renewal temporary and active well status approved by the chief of the well of the owner of the well may submit it with the chief of the applicant renewal temporary and active well status with the form prescribed and provided by the chief. Applicant shall include the detailed plan with the describe the ultimate disposition of the well time frame of the disposition any of the information chief determines if necessary. Chief shall either deny application by order and approve of the application. Chief to approve of the applicant. The chief to notify of the owner of the well. Chief to approval. The applicant with a temporary and active well status shall be accompanied with a non-refundable fee of $100, or an applicant renewal of temporary and active status shall be accompanied with a non-refundable fee of $250 for the first renewal, $500 for each subsequent renewal. 5F. Third renewal, the chief may require an owner to provide a surety bond amount not to exceed $10,000. Owners will have an approved of the chief of the temporary and active well status. Chief of the temporary and active well status with approved of the chief that expires 1 year after the date approved of the application of the temporary and active well status of the production well commenced with whichever they occur sooner. In addition to the renewal temporary and active well status 1 year after the expiration date with the initial temporary and active well status 1 year after the expiration date. Previous renewal of the temporary and active well status is applicable to the production well commences whichever occurs sooner. The owner of the well has been approved of the chief of the temporary and active of the well status that may commence for the production well at any time no later than 60 days after the commencement production of the well. Owner shall notify the chief of the commencement of the production. Chapter of the rules adopted with any term and condition permanent of the well for the applicable order. Chief of the plotted well has been approved of the chief of the temporary and active well status renewal of the status. Liability insurance coverage, except for the providing subdivision A1B and A2 with the section of the owner of the well, any level except for the Mississippi well, except for the domestic well, the trouble attainment of liability insurance of the coverage of the company authorized of the approved of the due business of the shade of the amount not less than $1 million of the bodily injury, coverage of the property damage, coverage to pay the damage of the injury of the body, or some of the damage of the property caused by the derailing operation, plugging of all of the owner's wells and the shade of the however the well is located with the unurbanized of the owner shall be the liability insurance coverage of the amount with not less than $3 million. The bodily injury coverage of the property damage coverage over the pay damage of the injury person over the damage of property caused by the drilling operation plugging over all the owners of the well in the state of the board of county commission of the county of the owner of the well board township trustee of the township of the owner of the well made elected to satisfy the liability coverage requirements of division A1A with that section participating in joint health insurance pool in accordance with the requirements established in 2744-081 revised code nothing division A1B of the section construes to allow any other county or the township to participate in joint self-insurance pool, satisfy the liability coverage requirements subdivision A1A of the section. Owner of the horizontal well should be the owner 10. Liability insurance coverage of the insurance authorized to write the insurance within the state of the insured with a proof of the right the insurance in the state within under the section 390533 provides cover with an amount not less than $5 million bodily injury coverage of the property damage of the coverage that pays damage injury of the person damaged property caused of the production operation of all owners wells in the state with the insurance policy shall include with a reasonable level of coverage available to the environmental endorsement. An owner shall maintain with the coverage required on subdivision A1 or 2 of the section of the owner and well plugged with abandoned or transferred owner with the obtained insurance required with the section who does not maintain who has not under notice of the material substantial violation of the suspension of the owner shall provide liability insurance cover the chief of the division of oil gas resource management upon request upon failure of the owner to provide proof of the request chief under the suspension of the understanding permits on the operation of the owner until the other owner provides proof of the required insurance coverage. B1. Except for the otherwise provided in this section, the owner and any of the well before the issue permit under section 150906 of the revised code before the operation producing of the well shall execute and file with the division of oil gas resource management surety bond conditional compliant with the restoration requirements of section 15090722 with the plugging requirement 150912 with the permit provisions 150913 with the revised code all rules and orders chief relating thereto with the amount set by the rule chief. The owner of the deposit for the chief inside of the surety bond cash in the amount equal to the surety bond prescribed with the pursuant in this section to renegotiable certified with the deposit a revocable letter of credit issued bank organized transaction business in the state having cash value equal to of the greater amount of the surety bond prescribed in this section. Cash or certificate of the deposit shall be deposited upon the same terms as over which the surety bonds may be deposited. If the owner deposits cash, the cash will be credited with the performance cash bond refunds created in section 1501016 revised code. The owner should deposit certificate of the deposit certificate required with the bank to issue with any certificate pledged with the securities cash value equal to the amount of certificate with excess of the amount insured by the Federal Domestic Insurance Corporation. Security shall be security of the repayment certificate of the deposit. Upon a deposit cash of the certificate deposit, the letters of credit of the chief shall hold the trust for the purpose for which they have been deposited. Instead of the surety bond, the chief may accept the financial responsibility consisting of the sworn financial statement showing the net fiscal worth within the state equal to twice the amount of the bond with a substitute that may be required by the chief of the listing of production using property of the owner, which of the day with the other evidence showing an ability to intent to comply with the laws and rules of the concern of the restoration and plugging with the may be required rule of the chief. Owner except the Mississippi well is not required to file the schedule with the update of the financial documents, but shall be file update with the documents if the request is to do so with the chief. The owner of the non-acceptable well Mississippi well shall file update with the financial documents in accordance with the schedule established by the rule of the chief. The chief upon the determination of the owner of the chief except for the proof of the financial responsibility instead of the bond cannot demonstrate the financial responsibility should order of the owner of the execute with the file board bond of the deposit cash for the certificate or deposit with the irrevocable letters of credit for the required section well specified within order to 10 days of the receipt of the order of the complied. All well owners are specified in the order in which no bond is filed with the cash deposit letters of credit deposit shall be plugged. No owner shall fail to refuse to plug the well on each day with which the well remains unplugged thereafter constituting a separate offense. The surety bond provides the section of the way executed surety company authorized to do business state the chief shall not approve of the bond any bond until the personally signed acknowledge of the both principal surety, either of the principal surety with the attorney, in fact, certified copy of the power of the attorney attached thereto with the certified proof of the bond listed with attached to a certificate of superintendent insurance company authorized to transact fidelity surety business in the state. All bonds shall be given with the form prescribed by the chief that shall run with the state with oblige. Owner of the except for the Mississippi well, except for the domestic well, with the lieu of filing a surety bond, cash in an amount equal to the surety bond certificate, deposit a irrevocable letter of credit, sworn financial statement at one-time fee with a $50 shall be deposited in an oil gas well plugging fund created in 1509-71 revised code. Owner and operator producer other person shall not operate well produced at any well time. Any owner operator producer other than those have not been satisfied with requirements established in this section. Or forfeiting a bond where the chief of the division of oil gas resource management funds that has the owner with the file to comply with the non-orderable issue with complying with agreement that enter within subsection 1504 restoration requirements of 1509-072 plugging requirements of 1509-12 or permit provision 1509 150913. Revised code rules, orders relating thereto. Chief may find with the act of declaring surety bond filed with the insurance compliance service. Sections rules forfeited the amount of the rules of the chief of the thereupon and certified with the toll forfeiture of the attorney general proceed with the collecting the amounts of forfeiture. In addition, the chief may require an owner and operator to produce the other person with a fortified super surety bond with a post with the use of surety bond with the amount of $15,000 for a single well, $30,000 for 2 wells, $50,000 for 3 or more wells. In lieu of the toll forfeiture surety bond, the surety owner operations may cause the well to be properly plugged, abandoned, the area properly restored, pay the treasurer estate costs of the plugging and abandonment. All the monies collected with the forfeitures bonds provided in this section shall deposit with the state treasury with the credit of the oil and gas well fund created in section 150902. Provision code. The purpose of the promoting competent management, conservation, sale, oil, natural resource, proper, lawful plugging of the historic oil, gas wells, which were not known reasonable owner with the chief of the annually shall be spend not less than 30% on revenue credited for the oil, gas well fund during the previous fiscal year of the both the following. According to the division E of this section, the plugged orphan wells restore the land surface properly required in section 1509072 revised code. According with subdivision F in the section, correct identification conditions of the chief of reasonable determinative of the cause of the imminent health and safety risk of an orphan well associated with the well or which owner is not initiated the corrective action reasonable period of the determined the chief of the after the chief of the attempted to notify the owner. The expenditure fund shall be made with a lawful purpose. Extension expenditure fund shall not be paid with the purchase of real property to remove the structure in order to access the well. Director of Budget Management Constellation Chief of the shall establish accounting code for the purpose of tracking expenditures make as required on the subdivision. C1 landowner discover the wells the landowner's real property landowner of the owner of the well landowner may report existence of the well with the writing of the chief of the receive the written report of the landowner over the discovery of the well previously unknown with the division chief of the shall inspect the well not later than 30 days after the date of the receipt of the land report. 3 of the chief shall establish scoring matrix with determining the prior plugging well with restoring land surface of the orphan well side with the purpose of the section matrix shall include the classification system categorize orphan wells high priority, medium priority, and low priority. Chief shall use the matrix developed within subdivision C3 of the section prioritizing plugging land restoration projects under the section. Chief of the made additional orphan well to project regardless of the classification D1 after determining the well with the orphan well the chief shall do the following: make a reasonable attempt to determine the records over the office of the owner county record over the county in which the well is located, identify with the current owner of the land the well is located, with identify each of the person right of the interest, oil, gas, mineral interest, identify with the other person in lieu of the equipment and permanent route into the well for the purpose of the division D1A of the section. Chief does not require to review the records office of the county record older than 40 years from the date at which the chief determined the well is an orphan well with a mail notice each of the identified with the person as a division D1A of the section, including notice each of the person in lieu of the equipment and permanent into the well. So statement with the information person with the well has been plugged, offering with the plug person operator to remove the equipment at the well site with the person's own expense in order to avoid forfeiture of the equipment to the state. Published notice of the newspaper general circulation county of the where the well is to be plugged and posted on the notice of the Department of Natural Resource website. If the current address of the person identified with the division D1A with the section determinative notice with the provide with the mail to the person under the division D1B with the section with the return undeliverable notice posted with the D1D with the section constitutive division notice of the person. And none of the person described in subsection D1A in the section required removes equipment from the well within 30 days of the mailing of the notice, publication, posting of the notice described in the division D1D of this section, which is later all equipment apparently on the well hereby declared to be forfeited to the state without compensation, without necessity for action in any state, using the defray of the costing of the plugging, the restoration, land source, of the well site with the chief of expended with the money with the oil and gas well fund. To propose the deviation divisions B1A of the section, such expenditures made within accordance with either of the following: the chief of the make of the expenditure for the person with the contract with entered into by either chief of another agency, state with the person agree with the furniture of the material, equipment, of work, of the labor of the specified with the provided contract activities associated with the restoration, plugging, orphan well is determined by the chief of another agency with the state. The entry of the intercontract chief shall prepare with the scope of the work of the restoration, plugging of the well. Activities may include excavation, uncover the well with the methods, locate the well, analyze the well, stabilize other work work or conducted prior to the plugging of the well, drilling out, with cleaning out the well bores, removing the material of the well, plugging operation, installation vault of the vault and systems, including associated engineering certification permits, and remove the associated equipment, the restoration property with replugging the previously plugged orphan wells or wells, provided with the final restoration was completed within Section 1509.72 revised code. Rules adopted under the repair damage to the property caused by such activity, the chief may expenditure for the sale of the maintenance equipment and administrative purposes for the cost directly attributed to locating, analyzing, stabilizing, designing, plugging, remediating, restoring orphanated wells, or determining of the well's orphaned well. Agents employed with the person contracting the chief to locate, analyze, stabilize, design, plug, remediate, restore the well may enter upon any land, public or private, of which of the well is located with the adjacent parallel needed to access purpose performing the work. Prior to such entry, the chief shall give the following person with a written notice of the existence of the contract located with the analyze, stabilize, with the design, plug, remediate, restore the well, the names, person within whom the contract is made with the date of the project commenced with the owner of the well, with the owner of the land upon which the well is located, with the owner on land with adjacent pairs well that entered upon. The well is located in the same township with the town adjacent with the excavation works in the mine owner and leaser of the mine has provided written notice of identifying with the township of the chief at any type and at the time of the during the immediate preceding 3 years of the owner and leaser of the mine. The chief may include the notice of the owner and leaser mine additional information to the authorization to plug orphan well under Section 1509.151 of the revised code. The owner of the land over which at least one orphan well is located will receive the notice under the subdivision D1B of the section plug any such of the orphan well reimburse the division oil gas resource management at reasonable cost of plugging such well. In order to plug with the orphan well, the landowner shall submit with the application chief at the form of the prescribed of the chief approved with the technical advisory oil and gas created in 1609.38 with the revised code. Applicant with a minimum shall require the landowner to provide same information as required to include applicant with a permit to plug and abandon the Section 1509.13 revised code. Applicant should be accompanied with a copy of the proposed contract with the plug and abandoned with the orphan well with the proprietor of the contractor regularly engaged in business with the plug and oil gas wells. Proposed contract shall require the contract furnisher of all the materials including the work or labor necessary for the plug with the orphan wells properly and restore the estate within site, including removal of all associated equipment, and shall satisfy with the price during the work, and the contractor shall be insured. Expenditures made under Section E2A with the sections shall be consistent with expenditure for the activity described in E1 of the section, and the expenditures made under the subdivision E2 with the section subject to 127.16 revised code. Applicant constitutes the applicant with a permit over the plug purpose of 1509.13 revised code. Applicant with not subject to the fee otherwise were under this section. Within 30 days after receiving the applicable company proposed contract under Section E2A with the section, the chief shall determine the plugging would comply with the applicable requirements for the chapter of the applicable rules and adopted orders issued on whether and under it and whether cost of plugging in the proposed contract is reasonable. The chief determines if the proposed plugging would comply with the requirements on the proposed cost of the plugging is reasonable. The chief will notify the landowner determination issue with the landowner of the permit to plug within Section 1509.13. Chief may disapprove of the applicant submitted within subdivision E2A with this section. The chief determines if the proposed plugging does not comply with the applicable requirements chapter of the applicable rules adopted ordered issued under this cost of the plugging under proposed contract or unreasonable. Proposed contract is not bona fide or arm's length contract. After receiving the chief notice approval of the applicant permit over the plug abandoned well under the division E2B of this section, landowner may enter with the proposed contract to plug the well. Upon determination of plugging will be completed with the compliance with the applicable requirements chapter of the applicable rules adopted the ordered issue under the chief of the pay with the contract cost for the plugging the restoration set forth by the proposed contract approved by the chief of the change with the cost of the approved by the chief of the payment that shall be paid by the oil and gas well fund. The chief shall only make the payments for the purpose of the division E2 with the section purpose of the proper invoice defined in Section 125.01 revised code. E. If chief determines plugging was not completed in accordance with the applicable amount, chief may not pay with the contractor or with the landowner for the cost of plugging. If the equipment removed with the well during the plugging is sold, chief shall deduct the scale amount with the equipment payment to the contractor change. The contractor changes made by the contractor executed under subdivision E2 section due unanticipated conditions may present to the chief of the form of the written request approval of the additional cost prior to the completion of the work. Chief shall determine the change with the necessary comply with the chapter of the rules adopted with the ordered issue and the cost of the change change is responsible. The chief of the may provide with a contract written decision regarding the proposed changes. Chief will determine the change if not necessary with the cost if it's not reasonable. The chief may enter with the denial with the request of the establishment with the cost for the chief of approved work completed prior to the receipt with a written approval. The chief is not eligible to payment unless waived by the chief. Chief may establish annual limit of the number of the wells that may be plugged during subdivision E2 with a section annual limit of the expense of the make under the subdivision. Chief may reject an application submitted to Division E2 with a section determines if the plugging of the other wells take priority. And using subdivision E2 with a section plugging include plugging of the well, replugging and previously plugged orphan well for a final restoration completed under Section 1509.72 of the revision code of the rules adopted under the drilling cleaned out well bore to remove the material well, insulation, casing, insulate the vault, vent, restoration of land surface distributed and plugging. Expenditure of the oil and gas well fund proposed with Division B1B of the section may pursuant with the contracts entered with either the chief of another agency with the state with the person with agree with the material with the equipment, work and labor specified provided in the contract. Competitive bidding requirements of Chapter 153 revised code may does not apply with the chief of the reasonable determined of the situation existing requiring immediate action correction of the applicable the health and safety risk contractor person material for the purpose of addressing emergency situation and not subject to the subdivision B of Section 126.7.16 Vision Code. Chief designated representative, chief of the agent, employee for the person contracting, chief locate, analyze, stabilize, design, plug, remediate, restore well under this division may enter upon a land, public, private, on which well is located on parcels needed to access the purpose of performing the work. Chief of the also issue an order requires the owner and well to actually document cost corrective action described in Section B1B of the section concerning the well. Chief shall transfer the money to recover the treasurer of the state with a deposit of money and the state treasurer of the credited oil gas well fund. Contracts entered on the chief of another agency stated in the section are not subject to any of the following chapters 4115 revised statute, chapter 153 revised statute, section 4733 or 17 revised code. Owner land on the well on which the well is located receive no notice on subdivision D1B of section in lieu of plugging well in accordance with the division E2. The section may cause ownership of the well to transfer in accordance with section 1509.31 revised code. A transferred owner of whom transferred comply with the chapter of the rules adopted shall title of the possession and equipment of the parent into the well to identify with the chief of having been of the former owner of the well. Chief may engage corrective projects under the section agency with the state of another state of the United States, the other governmental agency, state, university, college defined in section 334527 revised code. Non-profit corporation except for the federal income tax under section 501c2 Internal Revenue Code of 1986, Title 26 United States Code 1 has amended contract entire into the for purpose of the corrective project is not subject to Division B of section 127 and 16 revised code. J1. On or before the close of each calendar quarter, the chief may submit a written report with a technical advisor or council established under 1509.38 of the revised code describing the effects of the effort of the Division oil gas resource management plug orphan wells during immediately preceding calendar year quarter. Chief shall also include with the report of the following information: total number of the known orphan wells in the state, the total number in each county of the state, with the total number of the newly discovered orphan wells during the immediate preceding quarterly calendar quarter. Total number of the well plugged in accordance with section during the immediately preceding calendar quarter. Total number of the wells in accordance with the section. Estimated average indirect cost plugging activity conducted under this section prior to the date of the report. The number of the wells approved with the plugging in accordance with this section. Estimated average indirect cost of the plugging activity conducted under the section during immediate preceding calendar quarter. No later than 30 days after the March each year of the chief of the technical advisory council shall the joint provide a report containing a minimum of the information included with the quarterly reports previous to the 1 year period to allow the following: Speaker of the House of Representative, President of the Senate, Chairman of the Committee of House Representative Reasonable Energy Natural Resource Issues, and the Chairman of the Committee of the Senate Reasonable Energy Natural Resource Issues. Duty to restore land surfaces Now, no oil gas well owner, agent of the oil and gas well owner fail to restore the land surface of the area to distribute disturbed siting, drilling, completing, and producing the well as required in this section. In 14 days after the date of the upon of the drilling of the well, with a completed total depth of the in an urbanized area, with the 2 months after the date of the upon the drilling of the wells commenced in all other area of the owner and owner's agents, in accordance with the restoration plan filed under subdivision A10 of the section 1509 6 of the revised code. The file shall pit the containing brine and other waste substance of the result of the obtained produced in connection with the exploration, drilling, of oil and gas for the not required for the other state of the federal law of regulation, removing all the drill supplies and drilling equipment unless for the chief of the division of the oil and gas resource management approved with a longer time period. Within 3 months after the date upon the strip of the drilling of the well commenced with in an urbanized area within 6 months after the date over the surface of the dwelling and the well commenced in all other areas, the owners and owner agencies shall grave the terrace and plant seed sod area disturbed around required in production well wherever the necessary to bind the soil with a preservation of substantial erosion sedimentation. If the chief finds that a pit is used for containing brine, the other waste substances, oil violation, section 1509.22, revised code adopted orders issued under the chief and they required the pit to be emptied and closed before the expiration 14 days, 3-month restoration period. Within 3 months after the produced oil and gas plug urbanized area, the 6 months of the well has been produced oil and gas plugged in any area. After plugging in any dry hole, the chief approved the long period of time the owner and owner agencies to remove the production, storage, structure, supplies, equipment, and oil, salt, water, debris, and file any of the remaining excavation period of the owner agency shall grade the terrace and plant seed sod area to disturb by the necessary to bind soil, prevent soil substantial erosion sedimentation. Owner shall be released of the responsibility to perform all restoration requirements in section end of this section. Any of all the disturbed on the following request, the waiver they obtain with the written approval of the chief of the request should be designed surface of the owner certifying with approval of the surface of the owner over the release sought with the chief of the approval of the request over the chief finds an inspection when the waiver shall result in substantial damage to the adjoining property, substantial contamination surface of underground water, substantial erosion sediment. Chief may shorten the time periods provided in subdivision A and B of the section, and the further shorten the periods will likely result in the damage of public health or waters of the natural resources of the state. Chief, upon written application, owner and owner agents showing reasonable cause may extend the period with the restoration shall be completed under divisions A and B of this section, but exceed a further than 6 month period except for the extraordinarily adverse weather conditions or essential equipment, fuel, labor is available to owner and owner agents. Chief refuses to approve request waiver extension. Chief shall do so by order. Alright, fluid drilling requirements. A person on the issue with a permit under the Chapter 2 drill while a new well or drill existing deeper to urbanized with shall establish the full fluid drilling conditions prior to preparation of the Ndonga limestone. Continue using a fluid drilling unit until the depth of the well is achievable, unless the chief of the division of the oil and gas resource manager authorized such drilling without using fluids. Analysis of the disposition of material resulting in the construction operation plugging a horizontal well. With regard to material of the result of the construction operation plugging a horizontal well, the following apply. Except as provided in subdivision A2, the owner shall determine the concentration radium of the 226 and 228 representative samples of the material of the technology to enhance the natural occurring of the radioactive material. The owner shall provide with the collection analyst for the representative samples of the material of the collection analyst for the representative samples to perform in accordance with the requirements approved by the chief of the division of oil and gas resource management. Owner shall not remove the material located associated with the production operation horizontal well analysis is complete with the result available to have the owner may do one of the following. Temporarily store the material in adjacent location associated with the production operation of the well with the result of the analysis of the representative sample pending with the material located in the area with the designated with the division of oil and gas management with the owner comply with the conditions imposed by the chief. Prior to the collection, representative sample under division A1 of the section transfer of the material located with the permanent order has been an issue with another under division C. 1509.22, the revised code shall provide with the collection representative the samples of the material at the location and of the division shall temporarily store over the material of the location with the result of the analysis pending. Owner is not required to determine the concentration radium of 226 and radium 228 with the material of the technology enhanced naturally with the ongoing radioactive material in the following applies. The materials is reused horizontal well with the originated transfer with another site, reused horizontal well with the purpose of division A2A with a section of material, reused material is substantial similar manner originally used. The owner and dispose of the material inject well with the permit has been issued in section 1509.22 revised code. The owner uses the material in association with a method that enhanced recovery of the permit issued in section 1509.21 of this revised code. Materials transported out of the state of the lawful disposal. The owner shall retain records of substantiating the lawful disposal and provide them to the chief upon request. Instead of provided in Division A2 of the section, the owner shall transfer the disposal of the material technology enhanced naturally occurring radioactive material according to applicable laws. Material with a non-technological enhanced naturally occurring radioactive material. The material has come into contact with a refined oil-based substance. The owner shall do one of the following: if the material of the removed is located associated with the production operation of the well location specified with the permanent order issued in Division C, Section 1509.22, the disposal of the material is solid waste if it is authorized to accept the material in accordance with Chapter 3734 revised code adopted under it. If the material is removed with the location associated with production operation of the well location specified in a permanent order issued in Division C, Section 1509.22 revised statute code beneficial use of the material in accordance with the adopted Director of Environmental Protection under Section 3734 125 revised code. If the material is not removed with the location associated with production operation well recycle or reuse the material with approval of the chief. If the material is not technologically enhanced naturally occurring radioactive material, the material has not come into contact with refined oil-based substance, the material may be used at location associated with the production operation horizontal well with another location associated with the production operation. An owner who has obtained results of the under subdivision A1 section shall keep and maintain the result of the period of 3 years. In addition, the owner shall provide a copy of the results with the chief upon request. As the under the section technology enhanced naturally occurring radioactive material has the same meaning as section 3748.01 of revised code. An owner includes a person, the authorized agent of the owner. Termination of well coal bearing townships, and we're going to cut the tape there.